hello there, and welcome to the Disability Law Show. Good to have you back this week. John Scholes here, James Fireman with me as well, disability lawyer. Of course, Samfiru Tumarkin LLP is where you'll find James doing all the hard work. I'll tell you how to reach out right off the top here throughout the show as well. 1-855-821-5900 by phone, help@disabilityrights.ca, and more information, simply go to disabilityrights.ca as well. Follow our radio shows across the country and, of course, past episodes of this particular TV show. Lots to cover every week. We're going to get to some phone calls from one of our radio shows in just a bit. And the main topic, 3 important facts about your medical reports. That's a little later on as well with James, so stick around for that. But, brother, we always start off with a week that was, or something you've been working on and want to talk about. What do you got for us this week?
Well, I want to get a little bit fundamental here with disability insurance. The purpose of disability insurance is to provide you with a source of income when you can't work. It is not there to prevent you from returning to work if you are no longer prevented from returning to work because of a medical condition. And that is something that a lot of people really just don't understand. And there are reasons for that. So I want to get into that a little bit because it applies no matter what part of the process you're in. Those concerns show up. So let's talk about that. When we're talking about the application, or particularly when someone is actually receiving their benefits, there is a concern about trying to go back to work because people are concerned that if they make the attempt to go back to work automatically, that means that they're no longer going to be entitled to benefits if they're not successful. And that's a legitimate concern. Now, if you look at the standard disability policy, and there can be variants, but virtually every long-term disability policy is going to have what is referred to as a recurrence provision. What that means is that if you are in receipt of disability benefits, your insurer is paying you the monthly benefit month in, month out, and for whatever reason, maybe it's treatment, medication, what have you, you are feeling better. You are feeling as though you can return to work, or at least you might be able to return.
Give it a shot. Yeah.
Sure. And you go to your doctors, your therapists, and you discuss that with them, and they say, give it a shot. It might be reasonable. They may say, give it a shot, but don't do X, Y, and Z, or stick to this gradual schedule, whatever it is. If they suggest that it's reasonable for you to try, and if you are reasonably optimistic that you can succeed within those limitations, then absolutely you should try, because this recurrence provision says that if you return to work but have to take a further leave within a set period of time, usually it's 6 months, but check your policy. If you have to go on a further leave because of the same disability within that set period of time, then you're entitled to continue to receive your benefits after you stop working again, which is really important because most disability policies are going to have an elimination or qualifying period for the first 3, 4, sometimes 6 months. After you go on leave, you have to wait that period of time before you're actually entitled to start receiving benefits.
Latency period there.
If you are already approved, and you try going back to work and you're not able to do it within that recurrence period in the policy, you don't have to reapply. You don't have to wait that 3, 4, 6 months, whatever it is. So that is a very nice benefit of it. Now, from a practical standpoint, it doesn't always work the way that it should. And the concern that people have about insurance companies taking the attempt out of context and using that as leverage or a justification for denying benefits if you have to go on a further leave is understandable, because I've seen it happen many times. But that doesn't mean that you shouldn't try. I still strongly encourage anybody who feels optimistic that they can make a return to work to give it a shot, because the reality is your life is better if you are able to go back to work and earn your income and not have to rely on the insurance company, not have to deal with their claims handler calling and emailing, not have to go to the assessments that they tell you that you have to go to, which in fact you do have to go to, not sticking their nose in what treatment you should be getting. All of that is better. So if you can try. And if your insurance company denies your recurrence if you are unable to continue working, then we start a legal claim. We bring a lawsuit and we get them to the table as quickly as possible. So that's what happens if you are on claim. What happens in the other scenario, though? Let's say your benefits have been denied, or you were approved for a while and then they were cut off at some point, and you're disabled for another 6 months, a year, what have you. You come to us, you hire us as your lawyers, we have this mediation date coming up, and for whatever reason, you start feeling better after you've started the litigation process.
I get it.
What happens then? Well, my answer is the same. If you're able to return to work, and I cannot say this clearly enough, you can hold me to this, I promise you. If you are able to return to work, even if you've started litigation, you should return to work. Being able to collect 100% of your income is better for you than bringing litigation to try and recover whatever portion your benefits pay, usually 2/3, of which you're going to have to pay legal fees out of that. So if you are in a situation where you've started litigation and you want to return to work, you absolutely should. If you are with a lawyer who's telling you, oh no, don't go back to work, wait until after the mediation's over, I'm going to suggest you might be with the wrong lawyer. That's bad advice. If you are feeling as though you can return to work and your doctors support that, you should be returning to work. And I bring this up because this is a situation that happens not infrequently, not most of the time, but I'd say it happens maybe 4 or 5 times a year with my clients where they hire me to represent them. We bring litigation, we get a mediation date, and at some point before the mediation occurs, they say, you know what, I think I can actually go back to work. That's great. They can and should go back to work. And so what I do when they tell me that is I say, okay, try going back to work, give it 4, 6, 8 weeks, see how it is. And as long as you feel as though it's going to be successful, then I'm going to contact the lawyer for your insurance company, let them know you've returned to work. And in those situations, what happens is it's not as though you don't still have a claim. You still have a claim for the period of time that benefits ought to have been paid. When your benefits were cut off up until the date you returned to work, you're still entitled to those benefits. But because we're not talking about benefits on an ongoing basis, because you've gone back to work and you're no longer entitled to benefits after that date, it's usually quite simple to resolve that. And more often than not, we're not going to wind up going to the mediation. We can resolve it with a phone call and maybe an email or two.
I think one of the important things you said there is going back, and a lot of people don't realize they never get 100% of their income from the insurer. So it's tough to live on 60, 65%, right? So that should be incentive, no?
Absolutely, yeah. Which is why I encourage anybody who is able to go back to work to do so. PocketDisabilityLawyer.ca, fairly new website for you to use. As James broke down in earlier shows, it basically lets you know by going through a few questions if you should be and seeking a lawyer and making a disability claim. Again, do that anytime, PocketDisabilityLawyer.ca. It's free, it's anonymous, will not cost you a penny to do so, so have a look at that. Again, I mentioned phone calls or radio shows. You want to go to disabilityrights.ca. There's a media page there. We're pretty much on across the country, including the GTA here in Toronto, and we'd like to get some great phone calls on the show. We play them back here, James, and we talk about them. We'll get to our first phone call of this show right now.
My wife is LTD. She's been on it for 27 months now, and also on CPP. She's approved for LTD up till a future date coming up in a couple of months. And recently, she's been back to her family doctor to fill out forms from the insurance company evaluating her return. Doctor says she's not ready. Do we need to preemptively say, doctor says we cannot return to work on that date?
So this is a very interesting situation. You don't need to, strictly speaking, but I would strongly recommend doing it because this is really about framing. So think about what happens if you don't make sure that your insurance company has this opinion from your doctor that you can't go back to work. They're going to draw their own conclusions. Mm-hmm. And in a vacuum, it's not going to be hard for them to find something, even if it's not reasonable or even if it's not in fact the truth. They'll find something in your medical file that suggests maybe you can go back to work. And it's going to make it very easy for them to say, no, sorry, your benefits are cut off or denied or what have you. On the other hand, if you have gotten out in front of it, and you've gotten this opinion from your doctor puts it in a letter, supports it with their clinical observations, you send that to your insurance company. That's in their file now. They can't ignore that. Doesn't mean that they're going to accept it, right, but they can't ignore it. That is information that they have that is a positive opinion from your doctor saying that you cannot return to work. they must deal with that. And so now you've made their job a lot harder. Now, even if they hire their own internal medical consultant to look at the file, that consultant has to deal with your own treating doctor's opinion, knowing full well that the treating doctor is at an advantage because they've been able to see you in person. So it is really important that you take the time and send that in. If that opinion isn't there, what's going to happen? Your insurance company is again going to hire this consultant. They don't have to deal with your treating doctor's opinion because it's not there anymore. Right. So they'll just find any excuse to say, oh no, I don't think it's a problem. They should be able to go back to work. And let's say you subsequently, after your insurance company denies you, say, no, wait a minute. My doctor says that I can't go back to work. Are they going to send that opinion back to their consultant? Probably not. And then you have the claims handler saying, well, their doctor says that they can't go back to work, but our internal guy says that they can. I'm going to go with my internal guy, right? Like you've just made their job so much easier. So get that information to your insurance company sooner. The sooner you do it, the harder it is for them to cut you off. Now, they're pretty creative about finding ways to do that. But if they do it in that context, if they have the information from your treating doctors that says you cannot go back to work and they still deny your claim, especially on the basis of a medical consultant that has never met you, let alone assessed you, the way your treating doctors have, now there's exposure to bad faith, which could lead to an award of punitive damages down the road. So worst case scenario, you've still put yourself in a much better position if you ever need to litigate.
3 important facts about your medical reports. That's coming up, but we got to take a short break first, so we'll do that now and come right back with lots more. In the meantime, the number to reach James and crew, 1-855-821-5900, help@disabilityrights.ca. This is the Disability Law Show. Coming right back. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back to the Disability Law Show. I'm John Scholes. He is James Fireman. Samfiru Tumarkin LLP is where you'll find James doing all the hard work. Always encouraged to reach out. Make that phone call. Just that simple. 1-855-821-5900 for a private chat between you and James or a member of his team. help@disabilityrights.ca. Main topic for this show, as mentioned, 3 important facts about your medical reports. Number 1, James, it is vital for your doctor's report to be as detailed as possible. Yeah?
Yeah, it's very critical, but oftentimes that's not what we see. And that is in no way meant to be a criticism of your doctor or the medical field in general, because the reality is, although I've never been to medical school, I'm quite confident in saying that there isn't any time spent on dealing with disability insurance claims and how best to help your patients in that context. It's just not something that is part of the realm of medical education. There are doctors that are very good at this part of their job, but it is not seen by most doctors as a fundamental thing that they're doing. They're there to provide you with medical treatment. They're there to make sure that you are okay, that you are going to be in the best health possible, and that should be their focus. So I get it. I understand why when they are writing their clinical notes, they are focusing on what is significant to your treatment, your prognosis, your diagnosis, the proposed treatment, and so forth. And those are certainly relevant to the disability process, but it is not the critical question. The focus in a disability insurance claim is not on the diagnosis, it's not on the treatment, it's on your ability to function. And more important, it's on your ability to function in the context of your occupation.
Right.
That is a very specific inquiry. It requires not just a better understanding of your ability to function than most doctors are going to have in most situations, but it's also going to require at least some understanding of what is required in your occupation, what you do on a day-to-day basis. And that probably goes beyond just knowing that your job is teacher or your job is lawyer. It requires something more than that because our occupations are much more specific. Our duties and responsibilities are usually quite particular to the employer or the job that we have. And so making sure that your doctor understands what your situation is and how your disability, how your injury or illness and the symptoms that you are having impacts you on a day-to-day basis when you are in your occupation is really important. And it can be difficult to get your doctor to sit there and listen to you, but it is important that you try and make sure, if you can, that your doctor is going to put that in their notes and support that you have a disability that is preventing you from being able to function in your job. Your symptoms are preventing you from being able to do this part of your occupation or that part of your occupation. If it is a cognitive or mental health issue, it may be that you are not able to focus, that you're not able to multitask, that you're not able to follow directions, that you do not have the stamina to work on a particular task for an extended period of time. If it's physical, it's probably more straightforward, but it's still a matter of understanding what are the physical requirements of your job. So that type of information is really important. And where you can, you want to make sure that your doctor has that information and it's included in their clinical notes.
And that's exactly what number 2 is. Don't assume that they know, even though they may have been your doctor for 35 years. And to your point, if you work as an accountant, it's probably a smaller sphere of what your actual job is, whereas if you work in a car plant, the guy at the other end may have a much less physical job than you, so your doctor's got to know those details, right?
For sure. And I understand that doctors are overburdened. And so they really want to deal with each of their patients as efficiently as they can. And I understand that, and that makes sense. And so what you want to do is you want to make this as easy on them as you can. And so part of that can be simply just bringing a job description in paper with you. So they have that for their file, and they can take a look at that. If you force them to listen to you talk about it and recite as much as you can, some of that may make it into their notes, some of it won't. If you bring with you a job description, which you can usually get from your HR representative, and you are able to give that to them and they can put that in their file, then you've put them in a much better position to be able to provide that type of detail, to be able to say that your particular illness and the symptoms you are having and the limitations on your function are going to impact your ability to work in this way and this way and this way. And if you get that specific information and you provide that to the insurance company, you've just made it much more difficult for them to deny your claim.
Number 3 is this, pal. Doctors with patients that are applying for disability benefits are able to seek legal advice. Not only that, they should do so.
Yeah, we are absolutely open and have on many occasions consulted with doctors who just want to understand this process better. And I said this a couple minutes ago, this is just not part of any medical education. There aren't doctors that are trained in this. It is something that some doctors will learn from just having gone through it many times, or in other cases, they've learned from an older colleague, this is the way that you deal with it. But even then, there's a lot of misinformation about the process. And I have seen on many occasions very well-intentioned doctors who are looking to support their patient say things that they believe is in support of their patient's disability claim that actually work against them. So if you have a patient that is in the disability process, if you're a doctor or any medical treatment provider, and you want to get more information, give us a call. It is a 100% free consultation. You do not have to divulge any personal information about your patients. You can keep that absolutely secure. We don't need to know their identity. We're not going to require you to refer them to us in any way. This is 100% free. We're not getting anything out of it. It's just something that we feel that we ought to be doing. It's a service that we're providing because there's a lot of misinformation there. So if you are a medical service provider and you want that information, call us and we're happy to give it to you.
I think a bit of clarity, we've talked about this before, that's important, James, is there's a difference between what you're saying is, enlightening them to the process of disability law versus, oh, you're going to coach my doctor. That's not what you do.
Absolutely not.
Right.
In my entire career, and I can say this is true for every lawyer in my firm, we have never told a doctor, we need you to say this or to say that. A doctor's opinion is just that, is their opinion, and I do not need them to say anything that they cannot fully support with what they understand of the medical situation. I do not want any doctor to do that. I would never put a doctor in that situation. What I will do is I will explain to you what the process is and where the focus should be so that you can make sure that what you are writing is going to be as effective as possible in helping your patient. But absolutely 100%, that's an excellent point, John. Any doctor out there should not ever feel as though that they need to say something that they cannot medically support. That's absolutely correct.
And with that, we'll take another short break here. In the meantime, give you that phone number. Always throwing it out there for you to call James on your own time and your own schedule, 1-855-821-5900. Email is help@disabilityrights.ca. And to learn more, really easy to digest facts about LTD anytime, free, anonymous, ltdfaq.ca. And we'll be back with more of the Disability Law Show. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back, Disability Law Show. Thank you so much for sticking around this week. You can reach out afterwards to James and his team anytime. Always encouraged to make that phone call, 1-855-821-5900. Email if you prefer, help@disabilityrights.ca, or the website, mydisabilityquestions.com. You can type your questions in there. It's also searchable, which means there's a database with previously asked questions. Yours may be similar, thereby saving you some time. If not, leave it there, and James and his team will get to it. Again, mydisabilityquestions.com. From it, Ashton James says, guys, have been approved for LTD for almost 2.5 years now. Lately, my insurance adjuster has been constantly requesting updates. This has led to increased anxiety and seems to be detracting from any progress I've made with my mental health. Can I refuse to answer these calls? Am I able to request a new case manager?
So I would caution anybody against simply refusing to take calls from the claims manager. I suppose one can imagine the most extreme scenario where a claims handler is just going well beyond the context of their job and is so harassing that you just at some point have to say no.
They're the cable guy.
But I've never heard of that scenario happening in disability insurance. So, but for the lunatic fringe, leaving that aside, I really could not advise you to simply refuse to answer the calls. Can you request a new case manager? Absolutely, and you should. If you are feeling like you're being harassed or bullied, you absolutely should be requesting a new case manager. You should be putting that in writing, making sure that that's submitted to your insurance company so that they understand that the way that your claims handler is acting is having an impact on you. You want to make sure that that's documented not only in the insurance file, but also with your own doctors. Make sure that you go to your family doctor or your therapist or whomever you're seeing for your mental health, and make sure that you advise them that the interactions with your claims handler are causing you additional stress, additional anxiety, that they are adding to your depression. Whatever impact that they're having on you, you want to make sure that that is documented both in the medical file and in the insurance file. When you do that, you're going to accomplish a couple things. First of all, it's going to force your insurance company to take a good hard look and reconsider whether their approach is appropriate, and whether or not that they should reassign your file to a new claims handler. Both of those are good things. Both of those are the result that you want. You want them to be reconsidering that. But even if they do nothing, even if with that information from the clinical notes from your doctor and from what you've put in the claims file by emailing your concerns to them, even if they do nothing with that, you've still put yourself in a better situation, because if and when you have to bring litigation to recover benefits that aren't paid to you, now you can show that they have acted unreasonably. And in fact, you can show that they have acted in a way that has added to your situation, that has made your condition actually worse. And if you can do that, now there's a potential claim for bad faith. And so there can be damages on top of the benefits that they already owe. And really adding to the situation is the fact that Ashton has been paid benefits for 2.5 years. Right. 2.5 years is an important point in the disability context, because we know, as long as this is a standard disability policy, we know that after 2 years, there is what we call the change of definition. It means that the insurance company has to now prove that your disability is preventing you from any occupation. That is a tougher test as someone applying for disability or who's on disability to pass. So it means that if your insurance company has continued paying you benefits beyond 6 months, they have accepted for the last 6 months that your disability is so severe that it is not only preventing you from the occupation that you had, but from any occupation whatsoever. And in having done that, if now all of a sudden they're taking this different approach and they're starting to harass you and doubt you where they hadn't before, unless there is some reason for them doing that, then that is just going to create further exposure on them. It's going to make it more difficult for them down the road, especially if you bring litigation.
Let's get to Greta. We got time for one more email here. Greta writes in, says, I just learned that my second appeal of LTD denial was rejected by the insurance company. When I told my manager about it, he said that I should appeal again. He added that if that appeal fails too, he will likely need to lay me off.
Well, frequent viewers of our show will have heard me say this many times. It bears repeating. Don't appeal. Right. The appeal is really a waste of your time. Insurance companies are there to make money, and so they are looking for ways to either deny your benefits or cut them off if they've already started paying you. Once they have found that justification, it is going to be extremely difficult for you to change their mind unless you force them to be reasonable. Will the appeal process force them to be reasonable? Well, let's think about it. When you appeal, it's not going to some independent judge or an arbitrator or some third body, and it's usually not even going to fresh eyes within the insurance company. More often than not, your appeal is being considered by the same claims handler that decided to reject your claim, or if not the claims handler, then their immediate supervisor who approved of the claims handler denying your claim. So it isn't going to be reconsidered in any fresh new way. And unless the information that you're providing on the appeal is fundamentally different than what your insurance company already understands about your case, even if you have emphatic support from your doctor saying, I can't believe that you've denied this claim, it's not going to matter. If they already know what your case is and they've found their justification, even if it's not a legitimate one, if they have found whatever they believe justifies them in taking their position, you're not going to knock them off that position simply by bringing an appeal. The appeal is a waste of time. Now, where does that leave Greta in terms of her employer? Well, yeah, the employer may be threatening to do that if you lose your appeal and if you are not actively disputing your disability claim. But if you bring litigation, you are actively disputing your disability.
Right.
And your employer, as long as this is a group disability plan, as most of these are, your employer will be the named policyholder. And so what that means is they will be aware of the status of your claim. They're not entitled to know the specific details or your medical information, but they certainly will know the status. They'll know that you've applied, they'll know that it's either being adjudicated or that it's been denied, or that it's under appeal, or that it's in litigation. And if it's in litigation, if you brought a legal claim and that is ongoing and your employer decides to terminate you while your disability is in dispute, they've opened themselves up to a discrimination claim under the Human Rights Act.
So don't do it. And with that, we are done for the day. Always reach out to James if you have any other questions. Here's the phone number as we wrap it up, 1-855-821-5900 and help@disabilityrights.ca. We'll see you next time, Disability Law Show.